The penalty, right? The 51 and 58.
Yes.
Discount. So far penalty is 50.
Brother. Oh, give that.
I have also.
Even on the, what is it?
No, I have Anish Lordship judgment.
That is
Yes. Yes, yes.
Urgent copy. Item number 2.
Give the penalty and.
Yes.
Rest, yes, she's waiting.
No, advertisement is the last order. That's initial 11, page 176. But during when my page 176. They have my tender has been
176.
Resigned.
Yes.
The duration of your contract.
3 years. Yes,
September.
Like September 2026.
So
Now still,
were permitted till the last day of July. September.
but that is my tender not to be expired. My tender not been expired. Last can see my
Where is the tenure?
yes, yes, that is the last can see my advertisement. Sorry, that's the agreement. That is yes, a page 106.
106.
Yes, 107 MC. The subsequent page.
Yes.
Yes, ma'am. The tender will be well, one agreement. Yes, then
Not 5.
Period of engagement.
10
Period of engagement.
anyways, that is first page. 3 years. Then Lordship can see from the 110 to 23 till 26. Lordship pays 109. My engagement letter is there. 109. Yes, 109. Page 109. Lordship see that. That engagement letter issued to me. Yes. Married which refers to subject cited above.
May not.
Yes. But then Lordship see that the impugned order initial 11. What it says now. The 176 married that proceed of married blood. With reference to subject cited above.
The last sentence.
Yes. Yes, that is. So after
You accepted.
But-
To continue.
I
Yes, selected up to security agents.
agents for 3 years. That is for 3 years. Advertisement, the stipulation is there. Yes, after selection of a new security agency as per the RPF. After completion of my tenure.
No, terminated what means what?
There is a period on the
Expiring or terminated valid terms, that means it must be given the currency of the service period.
Having no reason,
What termination?
blood advertisement is as per the stipulation advertisement. That is also clause 4.1. It's clear said that That the last time 4.1.
The question of only 1 month.
Yes, but that is not a matter. Question is my tenure is not a mix.
Tenure has the.
Sir, no, sir, 1 month, 2 months, 1 month already have yes.
That means if you go, then your agreement after 3 years will terminate in September.
Yes.
So 1
Yes.
month.
Yes.
Then.
Then that is one of the grounds. Second ground is if my performance satisfactory, I will be allowed to 2 years extra.
Discretion.
That is there.
That's what a discretion.
What?
What a discretion.
It is a discretion.
Discretion that they can extend for 2 years. Does not mean that it creates an unfiltered right.
May I read the advertisement? That is.
No, I'm talking about agreement.
Yes, agreement. Yes, agreement clearly says agreement.
Says.
But agreement says that
It
it's
says
on.
further be extended by such and such for another 2 years based on
Yes.
satisfactory performance.
Yes, my. Yes.
So it's a discretion which is vested upon the authority to extend.
If they
Decided not to extend.
Yes, but
Right.
yes.
Legally enforceable right.
Let the discretion. That discretion cannot be arbitrarily exercised.
No, sir.
But
What's the discretion? There are.
then.
What judgment? I have brought the judgment of the Supreme Court, that is a judgment. Which has defined the discretion in a very lucid and elaborate manner. Taking aid of the police laws of England also, is 17 pages or 18 pages are invested on your discussion.
But suppose I had to continue it 2 years.
One judgment of the Supreme Court, they have very elaborately discussed about the discussion. What does it mean?
But discretion also is right. Discretion that should not be exercised in the arbitrary manner. That is my point, Lord. But what is wrong with me so that is terminated before?
Not before also. The point that the see the what the description is. If a power is given to do a certain thing, then the power is also ingrained not to do a.
That's true.
That's a discussion.
That is correct.
That's a discussion.
But in the instant
So,
case,
this is a discussion must be rational.
must withstand on the Wednesbury's principle.
Should not be caprice exercise of the powers, nor it should be arbitrary or something like
Right.
that. You understand?
right.
But if once the discussion is listed, it is open to them whether to exercise or not to exercise.
But if that will be done,
So
then
then
the meaning of the meaning of advantage.
tender.
That too. But the annexure 11, they say the agreement as per clause 6. Clause 6, what it says? That is for 3 years. 3 years.
True, so 3 years.
I have to complete.
2 months.
But 2 months, blood. 2
For
months.
2 months.
But 2 months, I am losing around 2 to 3 lakhs by that point.
We'll see to it, Mr. Ron, that if it is there, initially for a period of 3 years. That is activate, there is no indication that the performance is unsatisfactory. Otherwise, you would have terminated much earlier.
Right.
If you are not SC for 2, you have to continue for 2 months.
See, but husband has already, we have already,
Then pay their remuneration.
we have already moved in for the last 19 days.
Whatever, pay them, let them pay for compulsory for 2 months.
That was actually Indian Oil versus Amritsar Gas, that judgment. T-fact created.
The nice sloka. The nice sloka that is.
Maximum is entitled to this compensation, going by that.
That is
judgment.
what we said.
That is
Indian
what
Oil
I say.
That's
versus Amritsar Gas, the citation.
That page 109, annexure 5, which my lords have already seen, my lord, where it is
Last
stated that your service will be terminated after selection
I
of.
can take advantage my
After
that take advantage by my lord's observation.
After that, my lord, the next page 110. There, my lord, another letter was issued. Where, my lord, it was stated that your services are extended up to 31st March 2024.
That was challenged. That has been
That
challenged.
is challenged.
That has been challenged.
That is challenged.
That has been stayed.
So that matter is now pending, my lord.
Yes.
Yes,
But what we are talking about that you wanted to discontinue his continuance. Here's the initial period is 3 years. There is no anything, which is forthcoming that invites the customer. And that is up to September, they are entitled to rent, and then after they can't claim any.
Connected matter 14157. WPC. 14157.
141.
Month.
What concept is it?
Security.
14,960.
14157.
1,400, there is no which section like 1,400?
14157. The order dated 13/5/26. After hearing the respective counsels, we feel that the pivotal issue involved in the instant writ petition is whether the duration of a contract is to be ascertained from the date of the content month. He was my learned friend's client of this petition, right? My learned friend's client of the petition, and he had only challenged, it was his challenge.
So.
On his-
Matter, directed.
On his challenge, my lords, your lordship has vacated the issue order
Fresh.
and directed for advertisement.
Fresh.
Your lordship directed the vacated the stay and directed the advertisement.
Yes, because this
Advertisement be.
when the cause of action arose, the subsequent cause of arose, like now they cancelled. That was there, but now they cancelled. What can I do? But the subsequent the cause was arose, they cancelled my.
Bring those matters along with this so that we can dispose of with one go.
Yes.
It cannot remain. It appears that touching upon the
Same,
by which the petitioner was awarded the service. Number 3.
Item 3 is lordship
Point out that judgment,
if you can't, then I have to find.
institution has been described and defined, very clear. Yes, sorry.
Item 3, your lordship permitted to withdraw your lordship.
Who is for the other side? Perhaps objection.
Obviously.
State law, with no objection.
Quickly list item number 1.
Please, answering, Murthy Party.
Your Lordship, for Vapcos, we were supposed to file a VNAMA, Your Lordship, but it's in transits for which we could not
What
file.
do you mean transit? Does it remain? There
were
was
supposed-
also in transit. We do not know whether it is in transit or not in transit.
We were supposed to appear in virtually and address.
Whatever, it is not expected. Last time, On your prayer, it was, John,
I do agree to that.
we can't eternally wait for the lapses of the litigant.
Yes, I am appealing for opposite party number 1, Union of India, Ministry of Jal Shakti.
Do one thing, you pay off the dues, you pay, and then realize from them. But now it is your internal matter, you do it. Realize it.
Lordship may be allowed to just point out, Your Lordship, just one thing from the writ petition, subject to whatever Your Lordship feels. Your Lordship may see page number 14 of the writ petition once minutes.
Yes.
There is an arbitration clause, Your Lordship.
Oh, that's fair law and purest the judgment of the Supreme Court, you know where better.
Which my-
Will you or will you not?
Oh. Yeah, it's not disputed.
The instructions which were given to the vendors was that it was not a one-time or a lump sum payment which was supposed to be made. This was based on certain milestones, and eventually those milestones are not complete.
No correspondences ever made by you. He has executed the work, he completed it, he wanted the money, and it's given. You will withhold the money. That's why you say that Union of India will pay the money and realize it from me. Now fight with them. Show them all the objections. They will decide. The thing is this. We are responsible organizations. If we have you extracted the work from it, God. That's why the concept of legitimate expectation has grown. Expectation to receive the money. There is no correspondences they made.
Rather, we have made correspondence about the last
No, I understand. I am asking you. I know that what you have done. They have not made any correspondence.
no correspondence. Even on legal notice also they have not made.
Yes.
No objection. Which I say that if there is no dispute, but if it's such nature is not for the copy of it. Delivered is that clear? Where is that? The party, I think in both better or somebody is better.
Yes, ma'am. Maheshwar Behera versus State of Police.
Not some lady, sir. Improvements are not only made on the facts, sir, the law has also to be gone. Is the bench who has to discard it because he took a vital plea. That's. It's your duty to meet that. But the bench will remind him that what is the law. The very casual way, the very really casual way of appearing. Give me that judgment, why should?
We directly receive the WPC number. That is 32436 of 2024. Judgment dated 3rd December 2024. 32436 2020. That's judgment.
Ruling I have Surya Construction versus State of UP.
Vision. Out of
The point is what bill, release of the bill, is there any time limit that payment would be made within 2 months or 1 month or something like that? From the date of the.
Just have a prayer to calculate interest from 26 to 2020.
26/2 is the date of raising the invoice.
Yes, sir.
No, that cannot be. There should be some time which is given.
It's written agreement that workers hereby covenant
The date of. From the into this. Yes.
Superintendent need to be present, my lord. I directed my lord.
At P3 34 35.
You are exposing the cause of another person.
Not the cause of
You are a counselor.
well,
Everything has been done. If your internal problems, how can you come and maintain a reputation locus?
look
You are a
at the
counselor.
lost cost to the
No,
municipality.
sir, then you can't come in that way. You could have raised that in a different form.
But
No.
the petitioner ventilated the lost cost
An inquiry.
and a refund of that amount paid in excess to the.
Maybe that's the internal management. You'll have to go if there is any other hobnobbing things, but not in this.
Nothing has been brought to the notice of the authorities.
We have
Third party is right. You are.
we have brought notice to the authority. Well, under Annexure 1, we have brought that notice.
This nature is not permissible. Sorry.
We have brought we have brought this fact to the notice of the authority under Annexure 1.
They will take it action.
We pursue the remedy for the.
No, sir. You are espousing the cause of another.
No, I am not explaining the
Definitely.
cause of the
There's
municipality.
an internal management. There is already a municipality
Municipality.
consisting of several the councillors.
Chairman.
You dissented, but the majority have accepted. You dissented and you wanted to just spouse your cause. Dissent should be projected upfront. Why?
This is the.
The Yes.
Fine.
But execution is for
Yeah. How can you go for a lottery? Implies.
It is abolished. Abolished. Annexure 6.
Yes, it has been abolished subsidy. How can you go for a lottery?
Council, it notice has to go by, so.
Which one?
Opposite party number 3, executive
NS
officer.
notified area council.
Immediately, sir, but we are fixing this matter in the next week, short. You deposit the report for today.
Sir.
Give.
Work order is work order them is.
It has already issued, sir. Just wait. We have to cancel it.
Item number 6.
Put it into this today itself. Yes, what is that petition?
Or if it concerns the same tender.
Whatever, there is no interim order, only says that whatever the decision will be subject to the result.
Yes.
By you, how can you withhold it? Where is that petition?
So
It's pending before this court?
Yes.
Before whom?
For my lord, this honorable court will be the assigned bench yours.
This,
Earlier it was listed
Yes.
before.
any returnable date?
I'll check.
9773 of 2000.
I know, 9773 of 2025.
It will be my lord before this honor.
Because
now it is the
9773 of 2025.
Sorry.
Any returnable date?
No matter. Last listed on 1st May. Last listed on 1st May.
Directed to be listed?
24th June.
Thereafter, it's never.
2025. Sorry.
2025.
The
Let this matter be listed along with that, we will dispose of both the matters.
Yes.
It appears that because of the pendency of the another petition, WPC number 9773 of 27.
Item number 7.
Petitioner is minus 18.1 and all of them are given 0%.
Where is the order of rejection?
A rejection, my lord, they have issued a letter by an annexure court,
Whatever.
Page 32.
page 32.
Page 32.
Page 32.
32. my lord.
So you did not submit the requisite document.
They have alleged.
8 and 9.
They have alleged, my lord, but fact remains, I have annexed those documents in my annexure 2 series. What is there?
8 and 9.
8 and 9, my lord, if your lordship,
Where is that?
Clause, you will also turn to page. Page 17, mine. 17 is merit.
Exemption of EMD.
EMD, another is,
That he is.
another is no relation certificate. Those documents I have annexed to two series. If you will also turn to one is
Just 1 minute.
yes, ma'am.
Yes.
Page 26 that is the EMD document, and page 28 is no relation document, no relation certificate, and 29 is that affidavit filer, that annexer A, B, and this affidavit file.
Why you did not submit the whole of the tender document? Why you have not annexed in its entirety? Where is annexure A and B
Annexer as
to
per
the writ document? Clause 9 talks about the annexure A and B. The format.
I have downloaded the advertisement.
This you have selectively annexed the tender document. It must be there, annexure A and B.
Annexer A and B says, my lord, that
These are the format in which you have to file an affidavit and you will have to file a no relations article. I have just wanted to know that what is the format. If your affidavit is not in conformity with the format, then
I'm going to your lordship may grant me 1 day time. I will submit.
what is the instruction?
That's as per my instruction, he has not given the affidavit as per clause 8 and 9. The clause 8 which specifically says that engineer contractor desiring to avail the exemption of EMD is required to submit an affidavit to this effect that he has not yet availed the facility for more than 2 works. This affidavit he has not given. This is
So what affidavit he is annexed?
only affidavit which is
26.
page
Your lordship may turn
28.
to 26. That
No, I am.
but my learned friend is submitting, my lord. That is that affidavit. That I am the diploma engineer holder of the contractor, license is so and so, chief engineer so and so, may please allow exemption on EMD deposition.
Where you have said that you have not availed more than 2.
Yes.
Where is the one? That's why I wanted a format, sir, madam.
But I don't have the but
I
specific.
just wanted a format because the format must be very clear.
I'll ask for the format, but the instructions
So then
specifically.
then when you get an instruction, will you not ask for a format?
It's,
Because the clause 9 says it must be in a format.
yes, madam. See, they have given me documents which he has submitted, madam. That for that they have given me.
They have not received this. You know the Nazir Ahmed's judgment.
Thing has, yes, madam.
I'm thinking in that line
Yes, madam.
because it is not there in his affidavit.
No, madam.
That is what is clear.
Those affidavits only, relying upon those affidavits, they are saying that they have not submitted that.
He has not.
Yes, madam.
It's not so easy.
Well, I understand actually.
Will you not come?
Right, my lords, but specific instruction is that they have not submitted, my lords, specific instruction.
But submitted by the petitioner is.
Your Lordships, I appear on behalf of the petitioner. I am seeking quashing of a contract that has been awarded by Department of Health and Family Welfare. My lord, they are the respondents. My lord, I am a reputed Delhi-based
Where
manufacturer.
is your rejection?
My lords, due to some inadvertent error on the briefing council, my lord, that couldn't be placed on record. My lord, there is a my lord, I am not getting into that. My lord, there is a fundamental issue that goes to the root of the matter.
What?
My lord, this is not a case wherein the petitioner seeks to enforce a right to be awarded the contract. My lord, it is a
You are challenging because your bid was rejected at the technical bid stage.
please, my lord.
That's all.
My lords, may kindly bear with me for a minute. My lord, it is a case wherein the petitioner challenges the legality of the award made by the respondents after the very offer on which that award was founded. My lord, it ceased to remain valid. My lord, kindly see. My lord,
I could not get it what you really wanted to say.
My lord, I am submitting before this honorable court. My lord, I am challenging the legality of the award that has been made by the respondents. My lord, that has been made after the very offer. My lord, the bid document. My lord, the offer. My lord, the very offer on which that award is founded. My lord, that had remained to cease valid. My lord, I'll satisfy your lordships. My lord, may kindly have the.
He's really confused.
My lords, may kindly appreciate. My lords, may kindly.
Rejected on the technical itself. You still say that you're.
He wanted to say that I have no issues. My rejection is valid. But how can you award a contract to the other? He is saying, but what ground?
My lord, I'll satisfy your lordships.
What he is saying, nothing coming.
I'll satisfy your lordships. My lord, may kindly have annexure 1 for a moment. My lord, at page number 14.
Yes, please.
My lord, may kindly note the bid was issued on 13th of June 2025.
What?
My lord, may kindly have page number 14.
13 June, that is what? Bid document.
Please, my lord. My lord, may kindly note the bid end date was 4th of July 2025.
What?
And
The last date.
Please, my lord. My lord, and as per the bid document, the validity of the bid offer from end date was for 180 days.
Then
My lords, thereafter the bid was extended thrice.
Bid offer is valid for 180 days. Then
Please, my lords. My lords may then turn over to page number 91 of my petition. My lords, that is the extension that has been sought by the department.
yes.
My lords, on page number 91, my lords, the offer was extended up to 14th of July 2025.
Where do I get it?
My lords, this is
This is the
please, my lord.
corrigendum.
Please, my lords. My lords, up to 14th of July, thereafter up to 25th of July, and thereafter,
Then up to September 25. Then
please, my
26
lords.
September.
My lords, the bid document prescribes a validity of 180 days from the bid end date.
Correct.
My lords, my technical,
Can't they extend the time?
my lords, may kindly bear with me.
No,
My
no,
lords,
I'm asking, can they not extend the time?
please, my lords, they can. My lord, but the same is not reflected in the bid document.
How can it be? It is an extension of time. It is not really tinkering with any kind of a thing.
My lords, may kindly appreciate. My lords, my submission begins at
It's
the
still
point
open.
where the validity period expired.
When the award is contracted,
My lords, on 9th of June
contract is awarded to
2026.
him.
Yes.
My lords, on 9th of June 2026. My lords, that is after the expiry of the validity period. My lord, the reasonable question that arises and which goes to the root of the matter is that, my lord, what was the legal source of authority for accepting an offer on 9th of June 2026? When, as per the bid document, the offer had ceased to remain valid.
What is the offer? It is an offer from one side. Now we are entering into the very nuances of a contract law.
Please, my lord.
What is an offer? Somebody offers.
Please, my
I
lord.
wanted to give you this.
Please, my lord.
Then if somebody accepts, and if both the parties they accept, does it become invalid? I'm just asking.
My lord, as per the bid document, my lord, there is a validity period that has been
Validity period is at the behest of the authority. That authorities may not accept, or this offer may not remain open to be accepted after a particular period. If the authority subsequently accepted it, then this offer remains valid. That's a very fundamental of the Contract Act.
My lords, the
Offer and acceptance
my lord, the
constitute
offer
a
had
concluded
expired.
contract.
My lords, may kindly appreciate. My lord, the offer had expired on 26th of March 2026. My lord, after an inordinate delay
The
of
extension was done. Mr. Das,
Para 7 of the writ petition for Lordship may kindly see.
what?
The bid was extended thrice up to 14/7/2025 till 4 p.m. up to
No, he has taken us to this page where corrigendum talks about 29th of September.
Yes, 26/9.
26th of September.
2025.
Yes,
No?
that is the last extension which he says.
Which he seeks means he is not seeking.
Which he says, my lord, he has averred to that extent in the writ petition.
Sir, we are more on a document than anything else, sir.
Yes.
The document at page 91
But
is your document.
91.
It talks about extended. Last extension, it is up to 26/9/2025. No problem.
Yes, 26/9/2025.
No difficulty. He says that yes, it is extended. Thereafter what?
My lord, if my lords will appreciate, my lord, if 26th of September is the operative bid end date.
I simply ask that whether there are two things: awarding a contract at a later stage and finalization of a tender at the earlier stage.
Yes.
Was it finalized within the extended time?
But you may kindly have a glance to that document that is at page 40.
Yes.
Page 40 is the rejection of bid.
No, that is his bid. What is the date?
But your lordship, that rejection of bid, that was on.
Yes.
My lord, 17/1. The petitioner's technical bid was rejected on 17/1/2026.
There. I do not find this date.
That date, that is not here, madam.
No, no, where?
As per the averment made in the writ, I am saying, I have no instruction. But as per the averment made in para 8 of the writ petition, I am making such.
What?
Para 8 of the writ petition.
No, why you are going by that? What the document says?
Document alert note.
Whom the contract has been awarded.
Contract
Has been awarded to respondent number 3.
What is the
Respondent
name? Just give me.
Dynamic Tracom Private Limited.
Yeah, so that was on that was then executed on 25/9. And then status is qualified.
Yes.
First serial number 1 on page 40. That is 1 day prior to the offer validity.
Yes. Yes. His participation has been shown,
Yes.
but the date of opening of the technical bid, that specific date is.
Because the difficulty, what I am asking is, the difficulty which has arisen. One is the date for submission of the bid.
If your lordship will look at annexure 14, it
Because
says bid offer validity.
Yes.
Bid offer validity.
That is, no, I was just thinking in a different sense. Does it correlate with the submission of the bid by the intending bidder, the extension?
Yes, but my submission would be yes. It is only with respect to submission of the bid.
That is
Not-
what I was just thinking.
Yes, not decision.
Not. It appears that you have opened before. Page 40.
Page 40.
14/7 you have opened. Council again.
It's not 14/7. It is 17/1/2000.
No, please come to page 40.
It's I'm at 41.
Please. We participated on, have you seen?
Yes,
47.
yes.
47 number 5, 6, 7. If it is a last date of submission, then the opening should have been after 26 or 25th. Or after 26. Or before 26.
My lords, coming to the
It
second
is
fold of
after
the act.
26 only. The bids were opened after 26.
How can it
But
be?
that date is not here. Whatever,
Participated.
because
So you wanted to say that these are the participated means they have submitted their bid document.
yes,
on the
These
yes,
days.
on the following
This
dates.
day.
on that date.
Yes, but the bid was opened. If your lordship will look at para 8 of the writ petition, although I am not strictly relying on it, but para 8, he says my technical bid was rejected on 17/1/2026, which is after the last date. Para 8 of the writ petition, if your lordship may kindly see, page 5. Despite expiry of the bid validity period, the respondents continued with the tender process and proceeded to evaluate the bids submitted by the participating bidders. The petitioner technical bid was rejected on 17/1. So 17/1 is after that closer date. So what he is trying to intend that the
Is there
bid should have been completed within that 180 days. There should not be any award of contract.
Please come with the line, the validity of the offer
Yes,
is one thing, and the validity of the tender is another.
yes.
My lords, coming to the second fold of my argument. My lords, the bids of ineligible bidders have been accepted. My lord, I can satisfy your lordships within a minute. Within a minute, my lords. My lords, may kindly have, my lords, the past performance criteria has not been fulfilled by the successful bidder, that is the respondent number 3. My lord, same orders have been filed multiple times and I'll satisfy your lordships. My lords, may kindly have page number 113 of my petition.
File your response to it. Nothing more than that.
My lords, I am requesting that a stay may kindly be granted.
Refuse that this thing.
Please, my lord.
No entry order. File your response within 2 weeks.
My lords, if my lords would appreciate, my lords, just bear with me for a minute. My lords, may kindly have page number 113. My lords, this will satisfy this honorable court as to how the entire procurement process has been conducted in an illegal manner.
We'll see to it. You come with the evidence. We'll see.
Item number 10.
I'm deeply grateful, my lords.
My lord will seek permission to allow me to appear online, my lord. Yeah.
Even if we refuse, will you not appear on virtual mode?
No, my lord,
You will still appear on a virtual mode.
My lord, then I will appear physically, my lord.
No.
So sorry.
Yes, just give us 1 minute. So you have to take a decision on that. Either remove the encroachment or you foreclose the contract. Impossibility.
Now we are 4 years down the line.
Impossibility. Then you take it because he has completed so far as the bridge is concerned. But approach road and RE wall were because you have not acquired the land, you have not given a land for that.
But in the meantime, yesterday with telephonic instruction with the engineers, I could gather that the land has been acquired in the meantime. And regarding further instructions, I have asked them to provide the written instructions. If your lordship may
So if that being the position, then you
I'll
acquire the land, hand it over to him so that he will finish.
If your lordship may kindly inspire.
For the instruction, better to appear in the next week.
Next.
There is some positive, the positive vibes that has come from him.
My lord, in fact, 123 ASI has declared that this project is illegal. That will again be a problem. But anyway, my lord, let his reply come.
Now he says that everything acquisition has come, every authorities have been approved. There is every possibility that the road will be given to you.
Please,
Item 11.
Next.
But I am challenging the impugned.
Just 1 minute. He wanted to do it for you. Who is for the other side?
Lord, nobody has appeared because it's for fresh admission. Lord, it's a corporation, so notice.
2 weeks.
Lord, interim order, my lord,
What interim order? Repair work? Can it be halted?
No, my lord, your lordship may see my.
You see, you have said from your own cost you will do it, we'll consider it.
No, my lord, defect liability period is on.
Oh, that's true. I understand.
My lord, my lord.
Nothing. You are not charging any penny from them.
No, my
You say that at my own cost I will repair the defects.
Yes,
They are going for a repair.
my lord.
So you are not going to lose economically.
No, but at my risk and cost.
Correct. So that will be taken care of. We will say that since you have done it through their liability clause that goes. But you are heavy.
My lord, may you
2 weeks.
say
2
every
weeks.
work order shall be subject to result. My lord,
What cannot be done directly cannot be done indirectly.
the problem will be that.
Sorry, we can't. Problem is nothing. You are not going to lose a single thing. Only your warranty will take care of at the time of hearing.
My lord, may
That's all.
it's a
2
date.
weeks.
My lord.
2 weeks. They will give.
Oblate.
Item 12.
May I please? But a tender was protect. Just one minute. See, what is this? This one. This early resort is also there. Where is your contract? My lord, that's it. Where is your contract? My lord, it is agreement is at annexure 4, my lord, page 74 of the 74. Yes. What is the duration? Duration, my lords. That's it found initially at page 79 of the brief of September. It was initially 3 months. I am just asking, where is the duration? Where do I get it from this agreement? Page 75. The agreement was initially signed on that is on 30th of September. We understand 24. We understand. Sir, which is a clause where the validity or a duration is given. Page 79. 79. XIX, the bottom number.
9, clause 9.
Yes, XIX number. Oh, that's Roman 19. Roman 19. Yes. It is for 3 months. Just for 3 months. 3 months. Will be renewed. Consideration of further extension will be considered. Okay. Then sir, the 3 months means October, November, December. Gone. Thereafter, my lord's page 88. 88. My lords. In the bottom, my lords. The agency awarded the work of operation of the maintenance at just. This is an addendum. My lords. 33 months. My lords. It ends in September 2027. Yes. Now, my lords, a review meeting, minutes of meeting as each time was been done. My performance was being satisfactory, and in the height annexure, my lords, annexure 7, running page 114 of the brief, my lords. For the same work, they now floated another tender. Yes, sir. What do you have to say? How can you, when you yourself has extended it for a period of 33 months, subject to a further review to be done for further extension, how can you deny contractual? You are resigning from a contract.
There are two things. This agreement was with Puri municipality, Madhaj. And that was in pursuance to an tender floated by Puri municipality. Right. And here the new tender, Madhaj, this has been floated by the government. How can you? Yes, is it not coming under the municipality? How can a government impinge or invade upon the right of the municipality? This. Do one thing. Now, after their stand, let us be very clear. Municipality has awarded, continue to render your services under the municipality. Government now is awarding, let their agencies continue. Both of you continue, the people of the Puri will be benefited because there will be a very good cleaning throughout that. Let both of them continue. What is the difficulty? May I recall at least to one thing? Government has done it, let him take a responsibility. Municipality has already taken a responsibility. So both of them will work. There is no difficulty. Surprisingly, one thing will be similar. Running page found running page 104 of the brief. The same person is a signatory mallet here.
in the Puri municipality who was a party to the proceeding in each submitting swallow.
Sir, you are concerned with your services. If your services are protected till the period, let them. If the government want to spend more money, burn it. It's up to them. Let them burn.
I have received an instruction in this matter, Milord. They say, Milord, that on 24/6/2026, the Puri municipality was requested to terminate the agreement.
Have you terminated? Citing a ground?
Milord, that whether Puri municipality has done it or not, Milord, that actually Puri municipality has to answer, Milord.
Now, how can you float a tender when it was floated by the municipality?
No.
If a municipality is created, then all the infrastructures and everything vested into the municipality. Cleaning, these are the civic amenities or civic work or civic facilities within the municipality. Government will eat up.
Sir, the power of. Once we keep it to next week, Milord, I will take instructions, Milord.
What is the date of the new tender floated by the?
My lord, sir. The financial bid is, when the technical bid is open on, it is. Sorry, Milord, one. Annexure 7. The page 118, my lords. Opening of the technical bid is 12/8/2026. 12/8/2026. And other technical bid and other financial bid to open, let it be intimated letter, that is the.
Okay.
My lord, my submission is, my lord. The Assistant Director Tourism, who has protected this tender, is a signatory, my lord, in the municipality agreement. It is only the regional.
Yes. We are staying the further progress of this tender.
Now, let me keep it to next week, Milord.
No, sir. Then assure that you will not open the financial bid. You have not notified the date as yet. You have not notified the date. Technical bid is opened only on 12th.
No, the technical bid has been opened.
On 12th.
Yes.
And then the financial bid date will be notified later.
Yes.
At page 180.
Yes.
You have not. Then in that event, further progress have to be arrested. No further. Cannot proceed. No? You are still continuing?
My lord.
Pursuant to the agreement dated 30th September
In this matter, for
Yes. Yes.
Yes.
On the other side, it opens a very large issue. OPWD code, a legally enforceable document. You are banking upon the OPWD code. I wanted to decide whether it is a legally enforceable document.
That is enforceable. On tender consent, yes, Lordship.
No, they can't do it.
Lordship,
They can't. No, again, I'm saying it is an executive instruction binding on them, but a third party's right to enforce it does not.
Lordship.
You are enforcing
No,
that they are acting contrary to the OPWD code,
Lordship, can come to their own tender.
not under tender.
Tender code.
You participated?
No, I'm not.
Have you participated?
I'm not challenging the tender.
No. Lottery system you are challenging. What are you saying?
Lordship, can you 1 minute?
Without any authentic records, comparative statement, nothing of that kind.
1 minute.
No videography was done.
Only one. No, Lordship, that is not my.
Sir,
Lordship.
you have made out a case.
Lordship.
What are you doing? Not your case.
Lordship, just 1 minute.
I'm talking about from your pleading.
Lordship, that's no Lordship, but I'm just kind of done 1 minute. I can convince you. What they have done, Lordship, can you see? Lordship, the tender condition says, Lordship, is double bid system, Lordship. One will be technical bid.
File your affidavit.
Lordship, what are they submit, Lordship?
Wait.
Municipality.
Notice to municipality.
Lordship,
Notice to municipality.
Lordship.
Matter to appear after 2 weeks. Requisites by tomorrow. How can it?
Lordship.
They have not. It is not there.
No. In connected matter.
A connected matter we are not concerned. Maybe.
Same, I have quoted.
I do not know. Give a notice. Let them come after 2 weeks.
Lordship,
Let them come after 2 weeks.
Then interim order, Lordship.
No interim. 14.
Lordship,
Call.
Lordship, can let it tag that matter.
No.
Lordship,
Let it come. Let it come after 2 weeks. No, after 2 weeks. Come.
Lordship, then along with that matter, Lordship.
Where is clause 26.1?
Page 45, man. 26.1.
So that is the question of that. You wanted to service that once. You participated in the tender or not?
Yes, I participated.
Can you now? You have been disqualified?
Yes, sir.
This is Article 14,
Yes,
19.
Yes.
My lord, may see the NIT was dated 13th of May. The petitioner has all through participated. This clause was there since the very beginning. He has participated and after being disqualified, he has sent a representation. I am not yet served a copy of the writ petition.
I'll serve the copy.
Serve the copy.
Your Lordship may see,
I have gone through it. Your case is like that. That may be a pending. You have not been convicted. You may be exonerated. You may be found not guilty. That is a different. So according to you, this clause has invaded your right. Right. Let us see if the conditions are imposed. Come with the. You are for?
For OP number 1, my lord.
Nalco,
Record is the name.
submit that the copy of the writ petition. In the meantime, they have. In the meantime, nothing. No, I am not trying for any interim order. I am only saying let them disclose the name so that I can make my party. Well, let them come.
Item 15. May it please, Vinod.
Yes. Why are you not taking a decision? If you can't provide him a road, he has completed the bridge, you have also certified, yes, he's done it. What is this? Either close the contract, refund all the money, or what are you doing?
1 year minutes having, I can't participate, 75 lakh.
Kindly visualize.
Unable to.
Yes.
Yes.
Only thing is that direct to take a decision. Take a decision within 4 weeks. And communicate to you.
Lordship is disposing of?
Yes.
Great.
Unnecessarily will not.
Yes.
They have to take a decision. Yes.
His annexure may be referred to that.
Your representation we have seen.
No, his own annexure 300 feet paid.
Correct. They have to take a decision on that. They could not allot the land. You cannot make a construction of a land. Though you constructed the bridge, there is no difficulty. So either they have to provide you a land and to allow you to continue, or they have to foreclose the contract and refund the honest performance guarantee.
Refund. 4 weeks, madam. Grateful. Great. Item 16.
The judge, single bench, he is in session of the matter, he has not disposed of the matter. Go, let it be decided.
Sir, since I retired in year 2021,
maybe,
sir, 21, so the joint proceeding has been initiated. I approached this honorable court for yearly disposal of this proceeding, my lord.
Yes.
So they did not dispose of the case, my lord. So when I filed a contempt petition, so they issue punishment order against me only. Out of 3 persons, they have been joint proceeding has been initiated on the only to comply that order. To avoid personal appearance, they issue that order. 3 persons, no show cause has been given to the other persons also.
The What is the connect? Acha, connected is the part.
Look, my lord, the petition.
Just 1 minute. What is this? Any show cause? What are you doing? What are you doing? There was no show cause notice issued. Who is you are representing the Health and Family Welfare Department? So, any show cause was issued?
Let's see the
No,
last order.
did not find.
Let's see the last order. Last order.
Last order means
19/1/2026.
this 19-1 order. The document pertaining to service.
Let's kindly see flag A below. Flag A. That is the document, that is scope of notice. And the next page is similar to.
These are Meenakshi Enterprises. Huh? Meenakshi Swine. You are a proprietress of the proprietorship concern.
Right.
What is the date of the order? 31st July. No.
111 to 20.
Let's see, yeah. But actually,
Item 18.
It's last order.
Yes, why you are not making a payment?
Regarding the status of the inquiry, last order I produced, my lord, before the honorable court that there is an inquiry.
Yes, what is this?
The last order, your lordship directed regarding the status.
Correct.
This is what the instruction I have received. The partner that I have received from the department, but backside, if your lordship may kindly see, if in fact my office has committed a mistake, they could have xeroxed it different in a separate page. So what I suggest, my lord, your lordship may fix up a time limit within which they will conduct they will finalize the inquiry, and any findings or report that will be produced before this court or before the competent authority for final decision regarding release of his bills.
So there is already the committee has been constituted. A team of officials.
Yes, they have constituted.
They have been constituted.
And in fact, they have verified.
So they will visit the district office and complete the on-field verification.
Yes.
As well as the cross-checking of, that's the not cross-examination, cross-check. What are
They
it?
are not legally.
Word, English word. It's wrong.
Cross-examination. Director Health Services, yes.
What are the articles, my lord, I have supplied?
Oh, they are saying. They are saying. Look.
Wait, please, no.
Something. It is 2020 or 19 Arjun. How it makes is a mining matter. Mining matter today is not a mining matter. 19 Arjun.
Let's, demand was raised to the tune of 13 crores. Your lordship finds that at page.
Today is not a mining matter day.
It's a mining man.
That's why I say how it came.
It has been coming on every Wednesday, my lord.
Wednesday.
Why?
All mining matters.
No, this
This particular-
particular matter, my lord.
Why?
It has come.
Put it on the next Tuesday. When is the mining matter?
Extension of mining lease, my lord.
Extension is 64.
64.
64.
See, on the last occasion, there was no representation.
Oh, we are giving.
He will find.
Yes, my
We'll
lord.
file a representation. Just record that he will make a representation and within 64, within four or 6 weeks, whatever.
3 years, 2 months is the period.
Yes.
Great.
Item 21.
Yes, there is a allegation that you have awarded a contract who has submitted a false affidavit declarations. The performance even suppressed that there is an ongoing work.
Yes.
So, who is a party? Notice 2 weeks.
Milods, I appear for the OP number 5, Milods.
It's a
on
serious
advance notice.
allegation.
Milods, the work has not been awarded yet. Milods, a copy of the writ petition may be provided. I'll take notice, Milods.
Oh, you are for the. Oh, you take
Private
it.
OP.
Then,
Hello.
yes. Though the copy of the writ petition has not been served upon the opposite party number, is opposite party?
5. 5, Milods.
But got his name, appears and submits that he has.
It's not in order.
It's no difficult. Come on next witness.
Much obliged, Milods.
Last occasion, state.
Eight.
On one state, sought time for.
My lord, in this case, this arbitration process, this dispute between the parties has been resolved by Vivad to Viswas scheme. And your lordship, the sole grievance of the petitioner was that the bank guarantee that is
To
furnished.
create a viswas, there is already a vivad. We have to create a viswas.
No, your lordship,
Create
this
it.
is, lordship, I can file a compliance affidavit that it has already been disbursed since
Okay.
29/7/2026. Lordship, give me 7 days time, I can file.
Yes,
the
it is submitted by Mr. Kashyap that
Is gone. 33.
Item 23.
nobody. against the cancellation and the tender, I think.
After they're taking time to file an amendment application, my lords.
Yes.
Yes, have you filed an amendment application?
Yes, madam.
Where is that?
Copy is not being served.
Copy is not.
Even the
Flag
noting,
B,
noting shows it's not there. my lord.
IA. No, stay, where is the stay flag B? Flag A,
It's not been received.
when you filed, sir?
Yesterday. Yesterday.
Just
Yesterday we have filed, madam.
yesterday.
Copy.
It is submitted by the counsel for the prisoner that where is the order dated, annexure 12, which page?
At page at 182, madam.
Language is very confusing from the department.
Threefold argument that. First is an impugned order under Annexure 12
It will not spell out any reason, number one. Madam. Number two, I was never asked to participate in the review committee. Number three, Madam, the review committee does not deal with the hindrances which have been not ventilating by the annexures 5, 7, and 9, Madam. And I had shown the lordship a judgment of this honorable court for bench of the last occasion. That is the reason your lordship had to ask the government lawyer to respond to that. Thereafter, I could lay hand on another judgment of the honorable Supreme Court. Lordship allowed me to place only 5 paragraphs to that.
5 paragraphs.
Because this is 2015 volume 8 Supreme Court cases. Dharampal Satyapal Limited, Malad.
Yes.
Lordship kindly come to Malad, paragraph 27. Okay. It thus cannot be denied that the principles of natural justice are grounded in procedural fairness, which ensures taking of correct decisions, and the procedural fairness is fundamentally an instrumental good, in the sense that procedure should be designed to ensure accurate or appropriate outcomes. In fact, procedural fairness is valuable in both instrumental and non-instrumental terms. It is on the aforesaid jurisprudential premise that the fundamental principles of natural justice, including audio alterum pattern, have developed. It is for this reason that the courts have consistently insisted that such procedural fairness has to be adhered to consistently, adhered to before a decision is made, and infraction thereof has led to the quashing of a decision taken. In many statutes, provisions are made ensuring that a notice is given to a person against whom an order is likely to be passed before a decision is made. But there may be instances where, though an authority is vested with the power to pass such orders which affect the liberty or property of an individual, but the statute may not contain a provision for prior hearing. But what is important is to be noted is that the applicability of the principle of natural justice is not dependent upon any statutory provision. The principle has to be mandatorily applied irrespective of the fact as to whether there is any such statutory provision or not. Then, Insuenso captures the essence thus: where a statute authorizes interference with properties or other rights and is silent on the question of hearing, the courts should apply a rule of universal application and founded on the plainest principles of natural justice. Wade also emphasizes that the principles of natural justice operate as implied mandatory requirements, non-observance of which invalidates the exercise of power. In Cooper versus Swenso, the court laid down that although there is no positive word in the statute requiring that the party shall be heard, yet the justice of the common law would supply in omission of the legislature. Exhaustive commentary explaining the varied contours of this principle can be traced to the judgment of this court in Swenso, wherein the court discussed plenty of previous case law in restating the aforesaid principle, a glimpse thereof which can be found in the following passages. Well, I can skip over Malad because they are all reiterations of what has been read Malad. Then Lakshmi kindly come to para 35 Malad. Page 537. From the aforesaid discussion, it becomes clear that the opportunity to provide hearing before making a decision was considered to be a basic requirement in the court proceeding. Later on, this principle was applied to other quasi-judicial authorities and other tribunals, and ultimately it is now clearly laid down that even in the administrative actions, where the decision of the authority may result in civil consequences, a hearing before taking a decision is necessary.
Sir, 37 is more elaborative, sir.
Yes.
It says that where hearing and where hearing not, there's no hearing.
Exactly, Malad.
Everything. I was just trying to find out when you came with the judgment, because the question was not that. The question was that you were issued a show cause notice. You have given an extensive reply. If your ground which you have taken in a reply is not reflected in the order, whether it amounts to a violation of the principle of natural justice or impedes or affects the decision-making process. But you have not come with the judgment.
But in fact, what I complain about that.
No, sir. These are the judgments which are more broader on a principle of natural justice than this. Because writ court is not supposed to act as an appellate court of the administrative decision.
So that the best judgment on that is by Lord Tata Cellular. Here, 96 Supreme Court page 11 now.
That is on a principle of natural justice. Decision-making process and a decision.
Judicial review is permissible where?
No, I know. That is what I'm asking you. Where is your demonstration?
Well, I'm
It's not that.
I'm explaining for the facts what you see.
Explaining? You can't argue as a court. Is it Tata Cellular never says that the writ court will substitute itself as a court of appeal against the order of the...
That is what exactly it says, but it will not.
It will not.
It's not a court of appeal.
Yes, definitely. Show me that.
What I'm saying is, Lordship sees annexures, well, there are 3 annexures, 5, 7, 8, where I have stated categorically that these are the hindrances, and my hindrances, my grievances are not being addressed in the annexure 12. But if my hindrances are not addressed, or if not, when there is a fact,
the authorities have said that they have gone to a reply. You have failed. You have failed to mobilize the adequate manpowers, machineries, construction materials, could not achieve the satisfactory progress.
Exactly. I am exactly on that point.
No.
The coordinate bench of this honorable court said, I've given to that.
Give that.
I've given the last occasion.
Where is that?
Well, that is 1986 volume 1 OLR.
There is nothing.
631. I've given 2 copies.
Where it is? Where it is? It must be in the file.
Was it?
No, it was not going to happen.
I'm giving 2 more copies.
Which one you are referring? I got it. Which one? Shakuntala?
Yes, page 630.
You are referring Shakuntala's judgment?
Yes.
Yes, we are. Yeah. We are. Yes, which paragraph?
Lordship, in that judgment, kindly come to minute.
Which paragraph, sir?
Miller, page 634. Miller, last paragraph.
With the mark.
It
is not disputed.
It is not disputed.
Just give us. Just give us. Just.
Yeah.
Yes.
But what I need, Milan, they should have just given me a hearing. I could have explained everything, Milan.
What hearing?
But those things, Milan, annexes 5, 6, and 7, which are which clearly demonstrate that yes, these are the problems or hindrances for which could not be proceeded, Milan. But here it is, but this hearing would not be given, Milan, in a circumstance where there is no factual dispute, Milan. Milan, here there is a clear dispute with regard to them handing me over the site, giving a clear drawing, and there are so many things which are based upon which, Milan, the entire work process is dependent. So what I humbly say, if they have not given me an opportunity, I could have placed before them that these are the hindrances for which I could not achieve within the time. Without doing that, they have done it. But even looking at those documents, I humbly say it's not their own. It's similar. There is a purpose to achieve. The purpose is to not get the work done within the time. And for getting the work done within the time, they have to come out with some genuine attitude of theirs. That is not there, Malad. And
Yes.
then they have come out with this kind of order,
Yes.
which has got civil consequences.
Nothing.
And it's in 2014 9 SEC 105 Malad. It is a Gorkha security. It is a case of blacklisting. Extreme case of blacklisting also.
No, that is what we have considered.
Yes.
Crossan, Gorkha,
Yes,
what
ma'am.
not we have considered.
That 20
Erosion.
Yes, my para 20 specifically reads, I'll just read one paragraph, Malad. There is no dispute about the requirement of serving the shoker's notice. We may also hasten to add that once the shoker's notice is given, an opportunity to reply to the said shoker's notice is afforded. It is not even necessary to give an oral hearing, my lords. This has been specifically held in Gorkha Securities, my lords. Again, my lords, in Patel Engineering also.
Patel Engineering versus SBP.
Patel Engineering versus Union of India, my lords. In that, my lords, para 14, and I'll rely upon para 14 and 38. Para 14 only to say that this that right to contract includes right not to contract.
Who disputes?
Yes, my lord. And para
It's too fundamental. It's the first principles.
yes, my lord. And
Who disputes?
para 38.
So where that is involved?
Because we have terminated the contract because of the slow progress. That is, we had a contract between.
No. Who disputes that you have no right to terminate? But what he says is that there should be very, very strong reasons, and the reasons must be reflected for rescinding the contract or cancelling the contract or terminating the contract. This is what he says.
The impugned order, my lord, if I may read that.
So far as the department you have not imposed,
No, my lord, that is.
you simply
may initiate.
contemplated to initiate a further proceeding.
That has till date, as per my instruction, not been initiated of me. And here, my lord, specific reason have been given why the contract has been terminated, my lord. On the last occasion, one line of argument which my learned senior had did was opportunity of hearing is a must before in all these cases, or else there is a violation of principles of natural justice. My lords, recently, my lords, 2026 judgment, my lords. Para 79 onwards. 2026 SCC online. Input 549. Para 79. It's from 76 starts from principle of natural justice, objective and contours. And from para 79, right to personal hearing, visible discretion of the authorities. All the judgments from the very starting have been dealt in this matter. And the court have held that one, they have to plead prejudice. Second, whether all like your lordship has observed, what were the reasons or circumstances? The procedural aspect that showcase has to be given, reply has to be done. It is as per the contract. As per the contract, what was required was a rescission notice, which has been given, my lord. And as per the impugned order, specific reasons have been given why they don't want to continue with the contract knowledge.
Well, I'll place only one document at page 147.
That's your reply.
Well, no, in this expectation,
Yes.
Page 147, and except the work order.
Yes.
The tip of the iceberg balance. Lordship sees the date is 7th of March 2024.
Correct.
That is the date of work order. Lordship will kindly see the second para. Agreement drawn in your favor with the office contract agreement number so and so. Commencement is 29/2/24. Date of completion 29/12/24. And issued on 7th of March 24. But this is how well it has been done. That is why I said, give me a hearing. I will explain everything to you. Just the tip of the iceberg.
So keep it for orders in the next week. Send it to me.
I don't notify.
If anyone else content to the any so called today minutes. Focus today minutes.
Sugar means
because there are stuff people. You think then after
reply to a show cause or a show cause you will be fine.
So when you come back from Supreme Court, consider the content petition. So whole matter minutes with the most difficulty collect in papers and
I could not understand what you want.
they were preparing and filing it minutes. Will be taken up because you will file rejoinder, may file rejoinder. Minutes may be taken up any day.
You short me copy, then I will tell you that. Very good.
Was the order I do not know what. Week time or 2 weeks time?
So 1 week time will do.
Yes.
Last time only you had
I will
given.
file within 2 weeks.
Within 2 weeks. 1, 2, 3. Yes, next.
Item 26.
Under this case was disposed of the direction to the petitioner to file a recommendation with the director authorities and they will dispose it. He had filed a petition, but it is not dated. Go in here and file it. And I let it come next week. I will take inspection with it must not dispose of his maintenance.
It is submitted. It is submitted by the how second contempt petition is maintainable?
My lord, this is
I am asking you, sir, under what authority, once the court dismissed the contempt application, not finding any willful deliberate violation, how second contempt lies? Tell me.
my lord is
How second contempt lies? I am asking you, sir.
Lordship is correct, my lord.
So, tell me.
My lord is correct. Information secretary.
This is something is happening. Anyhow, 27.
Item 27.
What contempt?
Lordship may kindly have it done too.
Page
36.
I filed review petitions which are also listed. Second,
After review is no bar for implementation.
was my review has not been
Review petition is no.
But review petition, if it is there, then the court may hear review petition first and then proceed for, suppose if the order is reviewed, then definitely it will change the scenario, it will impact.
Had this matter substantially in the writ appeal, subsequently due to the change of the bench, it has listed before the other court.
No.
This is a recruitment.
Review, I am asking a review.
Yes, ma'am. Now let's kindly have the third matter. Review petition 99 of 26, Dr. OPSC versus Dr. Sanjay Patel.
Why the third petition?
90.
It is aimed against the single order.
No, it is aimed. There are two review petitions. There were two tagged writ appeals, so there are two tagged review petitions.
I'm asking, it is originating from a common order.
Yes, ma'am.
One order.
Yes,
So anyone will do. I wanted to see the order which you sought to review and to understand that what is the ground for review.
Well, I was prepared in the third matter.
That is second.
How
It's
does
a second.
Because it's a common order, no?
Common order, yes, ma'am.
Show us it is the one and the same.
Which one is that?
Your Lordships may kindly have Annexure 1, page 25.
I think you are appearing in all the review.
Yes, ma'am. I'm appearing in both the review petitions.
Both, though 2 or 3 or the 2.
There are two review petitions.
Just two.
Correct. What is the ultimate decision?
Yes, ma'am.
Where
My Lords may kindly have page number 42, that is issue number 3. Your Lordship framed 3 issues.
Yes.
Issue number 1 and 2 were answered in my favor. Issue number 3 was answered against me.
Right.
Issue 3, page number 42. Very well. Your Lordships have held that two candidates, Dr. Sripada Das and Dr. Devashish Sahu, were irregularly recommended even prior to revision of the select list by illegally relaxing the cutoff marks. And your Lordships have also held in the conclusion that the respondents who were more meritorious than these two candidates, even prior to the list, were not recommended, even prior to revision of the list. Para 30, if your Lordships may have, page 48.
I have already read it. 31 also read it,
Yes.
5 lakhs rupees.
Yes.
Then,
Well.
yes.
Therefore, may I take your Lordships first to Annexure 3, page 60.
Yes, page.
Page 60, Annexure 3.
What is this?
On 9th of August, my Lords, well, as I'm going sequentially, my Lords.
No,
No,
just,
we're going for again.
I'm asking.
I'll come straight to the point then.
No.
Annex.
What is the ground? First thing is there are 3 parameters of review.
Yes, ma'am.
Tell me first, you comes within which parameter?
Well, this is on the ground of error apparent on record.
Correct. Now you are taking us to page
Annexure 3, page 60.
60.
Yes.
Was it there before the
Yes,
court?
yes.
Page 60.
Yes, ma'am.
What it says.
Well, in this is the first select list that was published.
That has been taken care of in the judgment.
Yes, ma'am. Yes, ma'am.
Then what is there?
I'll come straight to the point. Your Lordships may kindly have Annexure 5, page 70.
Yes.
How Dr. Sri
Why?
and Devashish
Whether this document was also there
yes,
before
ma'am.
the
This is
single
part of an
page?
additional affidavit filed by the state government.
Page, I am not getting a page 70.
Page 70, Annexure 5.
I did not get a hard copy. It is not a page.
No, it is not there.
It ends 60.
They use paper, it's not there. It's probably with the page only. It's not the annex.
Annexure 5, page 71.
Yes. Where is that? Which file? Your
Well, it's PDF page 93.
we can get it in WA.
Well, it was part of an additional affidavit in the W.
That is what I'm saying. So we can get the file of the WA.
Yes, ma'am. It
Yes.
was part of Annexure D by 1 series.
Yes. Additional?
In an additional affidavit filed by the state government.
I do not find any additional
Additional
affidavit.
affidavit dated 30th of August 2024 filed by the state government.
Yeah.
Which was there in page 17.
Yes,
Well, Annexure 5, page 70, if your lordships may have.
yes.
This was a letter dated 11th of January 2019.
Correct.
After the select list was published in 2018 August,
Uh-huh.
state government writes, if your lordships may have the second paragraph, in this regard, I am directed to say that a list of 171 selected candidates received from the OPSC with a letter dated this were appointed as dental surgeons, with the department notification dated this, out of which the following 5 candidates did not join within the stipulated period.
Yes.
4 from the UR category and 1 from the scheduled caste category. It is pertinent to mention here that the state is running with acute shortage of doctors for which the government is taking additional measures to fill up the vacant posts in all peripheral hospitals of the state. It is therefore requested to recommend the names of 5 dental surgeons from the available selected list as per the aforesaid breakup to this department immediately for consideration of the posting at the earliest. Then your lordships may have over the page, Annexure 6.
What is this? Who argued the main matter?
Well, I had
Yes. Then what?
Then, well, 7th of March, I recommended 5 names.
Maybe that has been taken into consideration.
No, well,
Now there is, can't you visualize? Error apparent on the face of the record stands on a different pedestal than the findings being erroneous in
Yes,
nature.
Well,
If it is an erroneous finding, then you can go higher up and get it corrected. You are talking about that there is an error, means either this document has not been noticed. This document must have a very material bearing on the ultimate decision which has been taken. Had this document been taken note of, the position would have been different. If this document is taken note of but interpreted in a different way, then in that event it is an erroneous finding. It is not an error apparent on the face of the record.
These 2 documents have not been taken note of.
What are you talking about? This is what is, I think my brother is the best person who is an author of the judgment.
Well, if these 2 documents have not been taken, have not been referred to. Your lordships have said, interestingly, however, it is borne out of the record as admitted by the appellants that while the matter was under judicial scrutiny, the appellants hastily recommended the names of certain.
So that is what is given. You have recommended 5 names.
Well, this was at the behest of the state government.
So whatever, why you cannot expect the judge to write a judgment in the manner which you think ought to have been written. But you can't do it. You can't enforce.
I will refer to one sentence.
I think art of writing a judgment differs from a man to man.
I will refer to one sentence. This demonstrates that candidates less meritorious than the respondents were also recommended for appointment.
True, because he has said 180 point or 187 less than the respondent recommended.
Well, its respondents had secured less than these 2 candidates.
That was a second revised.
No, that was prior to the revision.
No, that is what is held there in paragraph 32.
It was after the revision, they have secured more marks than these 2 candidates. But prior to the revision, your lordships may also see paragraph 32. Your lordships have said.
I have said, admittedly, the respondent did not secure the revised cutoff marks.
Well, let me see. It is also evident that such accommodation includes candidates who had secured marks lower than the notified cutoff, both prior to and even after its
true.
Well, this was not the case.
No, that is.
Your lordships may kindly have.
That is what ultimate conclusion which comes.
My lordships may kindly have page 72. Dr. Sripada Das and Dr. Debashish Sahu had secured 188.102.
This is what is there. That is reflected in the order itself at page 36, paragraph 30. Yes, that is reflected 188.108, 187.
At this juncture, prior to the revision, Dr. Sanjay Kumar Panda had secured 184.210.
No.
Yes, my lord. That is that if your lordships have an additional affidavit, page 85, annexure 10. Annexure 10, page 85, if your lordships may kindly hear.
Which paragraph?
At page 89, there is a chart, my lord. At page 89, there is a chart.
Yes.
Serial number 1, cutoff marks as per the expert committee 189.558, marks secured 184.210. And Dr. Sripada Das.
Cutoff marks as per expert committee 192. Marks secured 191.
Well, serial number, well, that is as
serial number 1.
That is as per the second, that is after the revision. But prior to the revision, he had Dr. Sanjay Kumar Panda and
That is what a stand taken there, but the court did not believe it.
Well,
you have pleaded something in your pleading that does not become the mean that it becomes sacrosanct. The court has to take into account. If the court, after other documents and which is forthcoming, come to the conclusion.
These marks are not disputed. These figures are not disputed.
Then
these figures have not been disputed by anyone. These are marks which are in my possession. The answer scripts are in my possession.
Correct.
These marks are not disputed anywhere.
Correct.
Dr. Sanjay Panda and Dr. Anil Sahu have secured less marks than Dr.
Going in the analysis of
Devashish
judgment for erroneous judgment. No. It is not that nothing has been taken care of. Very minutely, each and every aspect of your pleading has been taken care of and it has been analyzed. What you intend to say that it has not been analyzed in the manner that you have argued. It's an erroneous judgment, you can say. Cannot be.
Well, it's just one sentence, man. This demonstrates that candidates less meritorious than the respondents were also recommended for appointment against the applicant.
There are documents. There are documents.
Well, that is post the revision, man. Not prior to the
pre and post, both. Pre and post. Both.
Well, there's one more submission.
That is how we have said that these people who have been recommended for consideration are also having less mark.
Yes.
But since you have considered doctors having less mark than the cutoff mark, you should also consider that. Because you have taken everybody leaving this school.
But your lordship's findings that even
before the matter was in fact adjudicated, surreptitiously the recommendation has been made by the OPSC to the government of all the persons, 171, leaving only the 2 who are in the court.
Well, these two were not even part of the select list. They had not secured the requisite marks. Dr. Devashish Sahu and Dr. Sripada, after the state government told me that please recommend another 5 candidates, we have a dearth of dental surgeons. After that, I recommended these 2 names. Even within those 5, 171 plus 5, 176. Even within the 176, Dr. Anil Sahu and Dr.
We have said that they are qualified.
Yes.
We also do not say that they are qualified. But the manner in which you recommended the other 171, you need to recommend them also. Nothing more than that. We never said that they are qualified. Is it your case?
Yes.
That is not the case.
They have filed an affidavit before this honorable court. 11 candidates securing less mark than the petitioners. They have been also given appointment.
Yes.
That is their specific affidavit. OPSC file. They are saying now the state file. It is the OPSC file. 11 candidates securing less mark than the petitioner. They have been given appointments.
Since the entire list has been exhausted, leaving the 2 who are before the court has asked to consider.
Well, the entire list has not been exhausted.
How many persons have been recommended?
Well, it's 171 have been recommended.
171 have been recommended.
Yes, ma'am.
What is the number of candidates then?
198.
198.
No, 198 is the total number of
Exactly. And 171 were recommended.
Yes, well, the remaining available posts are ST category posts. They are not posts belonging to the UR category.
So you say that the recommendation which has been made by this court now cannot be accommodated against the post that is lying vacant. That you mean to say?
No, ma'am.
That was your case.
Now they have put an advertisement.
He is proceeding on a wrong premise. come to paragraph 19 of the judgment.
I'm sorry, Wells.
You are harping on two names.
Yes, ma'am.
Please come to the paragraph 19. My brother did not restrict to two names. Please read. On record, the appellants have admitted, there is an admission record.
Yes.
That during the pendency of the proceedings, certain candidates who had secured marks below even the pre-revised cutoff marks were recommended and appointed.
Yes.
Then, two of such names means out of many, only two these persons are given, but it does not efface the other names which is already been recommended who secured the lesser marks. And then, yes.
Well, it's those.
Then come to paragraph 22. Those, they gave an example of two.
Yes.
Maybe example may be wrong, but it does not mean that admission is there that they were recommended. Go with the spirit of the judgment.
Well,
He has derived, the learned judge has derived something from your affidavit. Otherwise, it is admitted by you that certain persons who secured lesser marks were really recommended and appointed. He has proceeded on that basis. Now come to 22.
The present case, the respondents participated in a recruitment process where a uniform advertisement was issued, cut-off marks were notified,
True.
and the process was subjected to judicial scrutiny.
Correct.
During such scrutiny, candidates below the benchmark were recommended.
Now, this is why. That is what is a, don't go by two names.
Well,
question is a larger one.
Well, it's the, point, my submission is.
Actually gathered that two names, maybe, which is.
Annexure 6, page 71. At the behest of the state government, 5 further names were recommended. And
we do not know, are you succumbing to the state government?
What the first question that we had put to you? Why OPC is so much?
When you are undertaking an exercise of a recruitment, examinations are being done. Will you succumb to any extraneous force?
Well, this is not a
it's not a extraneous force.
Well, it's under rules.
State government has recommended, said, so even a less meritorious candidate which you found, you will recommend.
No, well, not less meritorious than the respondents.
Sorry.
Here the fact is, out of 100 questions, 14 questions answers were wrong. And they initiated inquiry, and on their expert committee reported that 14 questions in fact
unnecessarily, it's a review is not the jurisdiction to argue afresh. You can't argue. Sorry. This is your judgment.
More point.
Your judgment.
Separate point.
You give it to the brother. His own judgment is there. I think I have delivered at least 5 judgments on the review. Let it be disciplined. So my brother has to justify his judgment. So far as the contempt is concerned,
yes.
We are fixing on the next date.
Well, fix a time limit, we'll accordingly.
No, the next week for orders in the same way. Next week or after 2 weeks? 2 weeks. No. Review will dispose of within 2 weeks. And let the contempt be taken thereafter. Yes.
I'm great.
The hearing of the parties, those in contempt application as well as the review applications are
September.
already. I have a habit from there, so I can't change my habit of 30 years. So there is also 2 weeks, 3 weeks, but instruction is given that they will give you a date.
But can it be 9th or 20 or 23rd? 9th or 20th? 9th?
Yeah.
Item number 28. In contempt of SLP was filed, recently SLP has been dismissed. So we have some time so we can implement it.
So
we have some time, we will implement the order.
The contempt implement, come with the compliance. It's what order is violated, sir?
Annex 1, page 10.
Notice is issued. Notice has to go. It's a contempt.
What is it?
What is the date of the order?
7/7/2022.
26.
So before that, your lordships,
You are for?
I have a CBI, your lordship, Central Bureau of Investigation.
No. Are you in contempt?
Your lordship, this order doesn't stand at all, your lordships, because in terms of Article 226, Clause 3 of the Constitution of India, this order stands vacated, your lordships. Because this application has to be decided with, your lordship, I can come to 226.
No, we'll see to it. That is.
But your lordship, I had filed the application.
Who are you in a contempt jurisdiction, sir?
Your lordship, before that, your lordship.
You are not a party, sir. You should know the distinction.
Your lordships.
Are you there in the contempt?
Yes, your lordship.
I'm asking
Yes.
which LS contemptor? Which LS contemptor? Sure.
Article number 1, your lordship, Appeal Singh, DIG CBI.
Okay. So you have to be noticed. Give him a notice first.
Yes, your lordship.
But your lordships.
It's a contempt. It's not a writ petition, sir.
Your lordship.
First thing is the court, it is a matter between a contemptor. He is an informer. He informs the court that your order is being violated. Now it is a matter between a court or a contemptor. We wanted to just serve you a copy without serving a notice. We will not proceed on that basis.
Yes, your lordships.
You have to follow the procedure of law. You cannot override it.
But by limited submission.
We can't, on an oral submission, we cannot do it. It's a contempt jurisdiction. Can't you consider that? As a quasi-criminal jurisdiction. You are a CBI, you know when you try the cases, trial of the cases, you don't know how to do it.
Yes, your lordships.
Then
But your lordship, the
contempt can't be visualized. You may not be held guilty of the contempt. Whatever, the contempt may be dropped, but there is the procedure to be followed.
But by submission, your lordships, is that limited submission?
Very interesting. A witness turned hostile, then the entire case immediately should be dropped.
Lordship, there is a connected matter.
There is opportunity to the prosecutor to cross-examine him. He has become hostile.
But your lordship,
So immediately drop the case.
But your lordship,
The moment he become hostile.
hear me for 2 minutes, your lordship will accept notice. But your lordship, there is also a connected matter.
Is your client present?
No, client is not present, your lordship. But
Okay, then don't worry. You will get what you are expected to get. Having opened your mouth, you'll get it. Notice returnable after 3 weeks.
one limited submission, your lordships, there is also a writ petition.
We are concerned with the contempt. We are concerned with the contempt now. No difficulty.
Lord, 30 and 32, my lord, reply has come, my lord. I'll seek Lord's time to, my lord, 1 week time to file rejoinder, my lord. Very interesting issue. In fact, the reply per se is contradictory. At one stage, they said,
Reply is again.
The reply in 30 minutes says something else and a reply in 32 says something else.
Sorry?
Well, my lord would see their reply in item 30, files by same department or irrigation department. They say that it has to be only 1 paisa lesser than 15%, so it would be the compliance of clause 17. And in reply to 32, they say that no, it has to be 14.99%. So, my lord, I'm seeking lord's time, 1 week time to file rejoinder.
Yes.
32, we have not filed any counter.
32 years, they have not filed a counter.
Government has filed, my lord.
Huh?
We have not filed.
Private opposite.
Oh, private opposite party has filed a counter.
So that technical committee report there, my lord would see 32 for a moment and their interpretation of clause 17, my lord. 32, my lord, their reply page 16.
But without, let my learned friend argue 30 then. Let 30, we have filed the counter affidavit. If he wants to file a reply, then he can seek for adjournment.
No, he say that he has received the reply just now and he finds that two replies which he received in 30 and 32, both are mutually destructive.
So far as 30 is concerned, the state has filed the reply.
Correct. Now it appears clarification that in 32 actually they filed.
They have filed.
Oh. He has simply said, I received counter in both. He wanted to peruse this. Yes. Next week.
Deeply obliged, Lord.
Yes.
Grateful to you.
It is submitted that the copy of the counter affidavit has Thirty-one is gone. Same matter.
30 and 32 are gone.
Okay.
30 and 32.
I just 31.
31.
51 minutes. Yes, challenging the order of cancellation of tender.
It is not a single tender. What is the ground for cancellation?
Two tenders.
What is the ground of cancellation? Ground for cancellation?
Ground cancel. Page 29, man.
Huh?
Page 29, the ground of cancellation. Requirement of ensuring adequate competition and transparency. But my lord, two bidders were qualified on the technical ground. My lord, page 20, my lord, page 29, there was a table of 5 bidders who had participated. Out of the 5 bidders, my lord,
I am asking them if there are 2 bidders, why you have cancelled it? What are the other ground?
Page number 31, the informed order, my lords, due to
Yes.
adequate competition arising out of the qualification of only 2 bidders in the technical bid evaluation and with the objective to ensure maximum transparency, the committee has unanimously decided to cancel the tender process. Page number 31, minutes.
Where is
31 is
Page number 31, annexure 5.
I am not getting it.
Proceedings are at
Page?
Proceedings are at annexure 4. And
Can you do it?
I may hand over.
If there is a 5 participation, how many?
5 participants.
5 participation.
2 selected.
What more adequate participation you want?
My lord, I may be allowed to place something. I filed an additional affidavit in this case.
That
Yes.
is
What for?
Serve the purpose.
My record does not.
What do you want? Through additional evidence?
To show the arbitrariness conducted by the authority. No. Kindly have a glance at Annexes 6 of the additional affidavit.
Must be invited.
They have extended.
The yes. Withdrawn. Yes.
36.
Yes. Yes.
Open file.
Pay for some time, right?
What?
Personal issues is unable to come now.
Next week. A quotation. Give your name. Appears and submits that senior advocate, Mr. Such and such, is indisposed today. Apply to rejoinder. No, Mr. P.S. No. Sorry.
Take instruction about their new fact they have come to the.
Have they disclosed the new fact?
Yes, my lord.
Then a surjoinder you have to file, not a reply.
Terminology is correct, but here
It
we
is
are.
submitted by the learned DSG that
But next week, and that's I am not very well prepared in the.
I have no objection, only one thing. For my learning.
That's a very candid submission.
I'm not.
A junior is entitled to prepare herself in the matter, that opportunity.
I have no objection. Only saying that the identical matter during this honorable court was 6 similar tender was cancelled and same higher value retendered. State our or this on our high court set aside the cancellation and direct to give L1. This is one of the things, and the state prefer SLP. SLP was dismissed, and now the state accepted. My learner can only take instruction what is the stage of third tender. That is only, my lord. Because they are.
We are not recording anything on our prayer next week. Next.
Again. Hello.
But in this matter, we have already filed counter affidavits that will be taken to record. But because there is a notice in that counter affidavit is
Not received, yes.
Counter received, my lord.
No, there is a notice, now it has come.
Permit of.
Oh, you are filing, where is the original copy? It's a photocopy.
It is e-filed.
E-filed.
Electronic.
Have you served?
Yes, I have received, sir. It's an incentive small matter, maybe next week. Covered matter, early complete bonus for early complete.
Would you like to file reply? No, rejoinder, nothing.
The admission, I'll sort. If a lot is not required, I'll file spend. Yes,
We are keeping it next week. It is open to you to file it or not to file it. We consider.
Your Lordship, I am praying for short adjournment.
Next week.
A small matter in smart minors. And the opposite party of 5 minors. This matter, the tender inviting authority has decided to cancel the tender. They seek the leave of the court minors. They won't cancel the tender minor. The reason being, it's a tender for.
Consider it. Next week we are keeping it. Renew your pair. We will not grant any adjournment to you. That's the last prayer we are granting. He is appearing in person.
So cancellation of the tender only, my lords.
Maybe we do not want to go into all these aspects. On the prayer of the petitioner who is come at the priority. Then
Item 42.
Obliged.
Lordship, I'm for the intervener, Your Lordship.
who is for
I'm for the. Yes, the intervener.
allowed?
Your Lordship, I have also filed a vacation of stay. Vacation of state writ petition.
Without being implemented as a party, you have already filed the vacating application. Madam, she is seeking for a vacation of the interim order and you are consenting for implement.
Interim application for the intervention of the party to allow him as an intervener.
What?
Allow him as an intervener.
Allow. This is an application at the behest of the applicant.
Interim order pass on it.
Yes, interim order to continue till the next week. Next.
Item 43.
The good news for all of us, Mr. Mishra appearing on the other side has just cleared the collision yesterday.
Huh?
It's a good news for Mr. Mishra. I'm one thing last.
No, I understand. So where he is?
But he has not gone. He has not gone. I was expecting this to be one of the last cases.
Why last cases? Ready to argue?
No, but
Give him a last opportunity.
yes. Today I can't say no, myself. Sale has engaged.
When?
Next week. I will make some time. Only next.
Next week. Next week to be taken up.
Yes, sir. In the
Tell him to appear. Tell him to appear.
Your Lordship's two judgments we have taken up. My Lordship.
Keep it with you. Keep it in your kitty.
My Lord.
Disclose on the next day.
My Lord. Your Lordship was met us.
Item 44.
44 is that covered by your Lordship's already. Yes, sir. My Lord, that transport matter where.
Oh, that is.
My Lord, your Lordship judgment covers it, home transport. Similar, same Indian Oil Corporation.
I have already delivered Yes. Give it back. Keep it for another matter.
No.
One copy we have written.
Same exact, here is annexed.
Oh, yes,
Second
next.
matter is annexed 10.
1 week or 2 weeks? 2 weeks for orders.
Wait.
45.
Your Lordships, I'm appearing on behalf of Ms. Adisha Mahanti
Who is she?
from the BMC side.
Huh? Yes, what do you want?
My lord, please grant us a short date to file the counter.
This is the first extension. Was there a direction to file counter? What is the matter? Huh? Oh, then it requires, yes, you file your affidavit, counter.
Yes, ma'am.
2 weeks, 1 week, rejoinder 1 week, matter to appear after 3 weeks. They wanted to remove the power. It's tender cancelled. It has become infructuous.
Page 4 and 5 of that is
The instant repetition.
Page 4 is the government approval and
Is filed.
Cancel.
Lordship, please to direct them to submit the record. But record is available. Lordship, record is available. Last, kindly see the State Council statement that I have misled the court. Lordship, by
Document is enclosed as answer 4.
Lordship,
Bears no signature of the superintendent engineer.
that is
Where is the affidavit? Where is an affidavit?
Page 33.
Where is your affidavit, sir?
I will file an
Since you, why you will file? Since you raises a very serious issue,
Document is there with them. My client has gone there and inspected. The document is there. They're suppressing it.
have you taken the receipt for that?
No, Rashid, they did not allow. That is
No, give, otherwise they will. Otherwise we will.
Affidavit documents there. Otherwise, that's and
AGA 6 for.
Opposite part number 2 served us with the counter affidavit last week only. We need short time to file a rejoinder affidavit to the counter affidavit filed by OP number 2, which is the railways, your lordship, which is the tendering authority.
What is the could you understand?
As you are for opposite part number 2.
Yeah, OP number 2 we are for. 1 and 2 we are the company.
48.
I think it's the petitioner comes.
No, petitioner. Mr. Das is petitioner, no?
Yes.
Who is 48?
No, I think he had.
I think the concerned council is for item 48.
No,
Yes.
Right. He is there. He had briefed me in the matter.
Oh.
Yes, Mr. Das is leading us, your lordship.
So why you are interfering?
I'm sorry.
Your senior is already here.
I was under the impression Mr. Das was busy. I'm so sorry.
Yes, what he was saying.
He is saying that the rejoinder has been filed to the counter affidavit filed by.
Rejoinder by you have filed.
I am for the petitioner.
So you have filed a rejoinder or not?
Yes. Opposite party number 1 and 2 are the South is the East Coast Railway, and OP number 3 is the private opposite party. As far as the private opposite party is concerned, rejoinder is filed. As far as OP number 1 and 2 concerned, then I seek 1 week's time to file the rejoinder.
So say that you want to file a rejoinder against the counter affidavit filed by 1 and 2.
Exactly.
One line.
Yes.
The counsel for the petitioner.
The petitioner, I am the successful bidder, and my evaluation sheet is at 39, page 39. Your Lordship.
What?
They have filed a rejoinder affidavit. Copies are not served to us.
Yes,
You have not, sir.
Yes,
The
I have.
copy.
Yes, I have served copy. Even.
Where is show us the receipt?
Receipt is with me, but I am VC mailer. But I have served on date of filing mailer.
Show it in the VC.
Wave it.
Come in the next week. In the meantime, if they rejoin, it is submitted by the AG.
Lordship does seize. Page 160.
By whom?
By his honorable court, my
No, this bench.
Lordship, in that case, can be taken up next week, my lords.
This bench or what?
No,
It was come for.
no, the reconstitution of the bench. My lord, justice had not done that.
Sorry, then keep it with Justice Raman. We will sitting before him and on that day we'll take up these matters. Tuesday. It will come on Tuesday.
25th.
I just one sentence I'll continue.
Just one, this before Justice Raman, don't worry, that's why.
Same thing. Just one sentence. In fact, the Lordship kicked into orders.
That is what I'm saying. That is why with Justice Raman, there will not be any problem. We will dictate it in the open court. That is what we wanted to do it.
Tuesday.
It's Tuesday. There will be only these matters which are coming on Tuesdays. So it will be one of them.
What I believe was the request from the Honorable Supreme Court for further review.
We are doing it.
Yes. Okay.
I'm in VC, Your Lordship. May I please, Your Lordship?
Yes.
My Lord, this might take some time. Mr. Budhia is appearing for the other side. So, Your Lordship may call it next week. Is it possible, my Lord?
Next week. Yes.
I'm 59, man.
Record. Yes. 53. I'm exhausted. How many other matters? What is the matter?
My lord, this is 53, my lord.
Yes.
My lord, this is blacklisting order, my lord, without issuing any notice.
Oh.
My lord.
And it's
Is it admitted?
file a counter affidavit.
My lord,
Have you said that show cause? Today I dictated the order.
my lord's order there.
To close this.
Today also dictated the same order.
Yes, we have issued is page number 31, man, that's all. Correct.
54.
The city authorities were supposed to file a counter, this is a matter with the complete change in the purpose for which the tender was floated. It was floated for.
No. Who is?
Mr. Dayanand Mahapatra was supposed.
Where is he?
He went away.
Last time he.
No, he was
that's
there.
what-
He was here.
Mr. Mahapatra was appearing in one contempt, but he left word.
Call him in. Next week. Keep it informed that it will be taken up in the next week.
Maybe permitted to withdraw.
Yes, have objection? No. Withdraw. Record that he has no objection.
Item 56. Order.
56, my lords, I'm requesting for an adjournment on behalf of Mr.
Mr.
Naik, Mr. D. Naik for FC.
Yes, point out, my lord, I have no objection to that. Let us take instruction on the issue. Your lordship, just see the order dated 28/25.
Just take an instruction and come back on the next week. We are keeping
We have
this.
filed an IA because they gave the undertaking in the court that no decision will be taken. But in the meantime, we have already.
Yes, take an instruction and come back on the next week. If you have, then we'll see to it. 57.
7.
I have filed an agenda on South Properties, but here is same that after lottery, my lord, they will take instruction whether these similar to identical matter post lottery, this honorable court allow.
Have you filed it? Filed it here?
Yes, I have a rejoinder. I have annexed that same order and SLP order.
No.
Today.
You are filing it today.
No, already filed. Your lordship.
Filed on 20.
Already filed.
E-filing.
My lord, physical copy, hard copy is filed. Rejoinder.
File.
It is already filed, no?
Yes, it's already filed.
Not gone
It
through.
appears that the rejoinder has already been filed by the.
In this case, I have provided two IAs. IAs are pending. One IA is paying for appropriate direction to the opposite partner of 3 to release my articles which have been kept in the premises of the.
Yes, what you say, who is for?
I am appearing for the opposite party number 3.
The direction is upon you.
It's a purely personal dispute. Here, your lordship would see opposite party number 3 is a private entity.
Yes.
They got a railway, the contract from the railways for electrification of certain railway quarters. My learned friend's client was appointed as a subcontractor. There was some internal dispute for which I have restrained him because I had to meet certain obligations for the railways at the time.
Of your, towards your principal.
Towards my principal. This petitioner, my lord, he was not up, his work was not up to mark. Number 2, my lords, it was not within the scheduled time, prescribed time as if for the railways. So
Then how the writ lies?
That's my humble submission, Lord.
Yes, how writ lies?
Private dispute, a writ does
It is a matter between a contractor and a subcontractor. How writ lies?
And there's an arbitration clause which my learned friend has not divulged. It's not very happily worded, but there is an arbitration clause between the.
No, there is no. Give me the file. We will dismiss it here and now. You take recourse to the another forum.
Kerala Electricity Board, my lord, is very clear on this topic.
Heard by a single bench. How it has come? It is heard by a single bench.
Even otherwise, it should not have come.
It is to be heard by a single bench. There is an order passed by the single bench.
Because now, my lord, here, my lord, what has happened, even though it is a single bench matter, you have to appreciate.
Then how it is appearing before us?
That my learned friend can explain, because I am appearing for.
How?
Case was when assignment changed and all the work product matters have been assigned to the tender
This is not the question.
No, sir, this is a single bench has already done. You have gone.
As an interim order.
Yes. The matter has been wrongly listed before this bench, as we find that it pertains to.
Affidavit and I will supply a copy. Meantime, let they permit me to continue with the lordship of
only the contention before your lordship was that the opposite partner 3 had submitted a fake experience certificate. That is a wrong contention, your lordship. If your lordship may kindly see, your lordship, that affidavit only it is getting ready. Your lordship may keep it to tomorrow. I'll produce that affidavit.
Lordship, I have no problem. If they can show the document is right,
That is a
then I have all case.
ground there.
Tomorrow has to be mentioned.
Last.
Next.
Item 60. Item 60, your lordships. In the first matter, I am the successful bidder. We have not been made parties. We have filed an intervention application, but your lordship, there is an important thing I have to bring to notice. That this particular writ petitioner actually has suppressed a material fact from this court and has taken an interim order.
So you file order 39 rule 4 principle.
Lordships.
Find it. If there is a gross suppression of fact, you can ask for variation, vacation, whatever.
We have, first that has not come on record.
But you are not a party.
We filed both the intervention and both of them together. And
Who is for the petitioner?
Well, I appear for the petitioner in this matter. Well, I have just been.
What is your right? What is your right?
Well, what has happened in this matter is, there was a tender, in that
No, tender. There is a serious allegation against the petitioner that he has suppressed many facts.
It has just.
Have you not taken out? Why you have not taken out an application for vacation?
Already filed. We have filed the counter, we have filed the vacation also, everything.
Vacation application or
Today.
Today this.
Copy has been served.
Just now.
What is your right in relation to this? You are
I'm the successful bidder.
then you have a right.
Yes.
And they are challenging the tender.
Yes.
Yes.
The tender conditions or rejection.
Knowing well that he is a successful bidder, till then he has not met party. And on mention, he got the interim order.
So we are allowing the addition.
Your lordships may allow the addition. I will file my
Yes.
audit and do the.
No, it's not necessary. We'll see to it. This is.
I have the additional affidavit for Union of India. That will submit.
I think your lordship's next Wednesday is a holiday, so I was wondering.
Oh, it's a holiday?
Yes, your lordship's a lot of.
Oh.
Can be on Thursday.
Thursday, your lordship.
Can be on
Because it's
Thursday.
Wednesday.
Thursday is for?
Tax.
Now, no longer the tax.
Excise.
Huh?
Excise.
Public interest litigation and excise.
Medical
Tuesday?
expenses, their medical supplies, CGHS medicine.
Nice, okay. And Monday? Come a day after, the week thereafter. Some on the week thereafter. 26 thereafter is third. Second. Keep it on second. Next.
Short point involved here is this, my lord. As per the Orissa Civil Supplies Corporation's, my lord, their own guidelines.
61 I have appeared. I have already received the instructions file and filed within a week the reply.
I am also sorry. Both.
I'm not able
I am also not able to understand what he says. Sir, what you said?
61 I have appeared, your lordship.
So what?
I have appeared, I have received instruction, I want to file a reply.
He will file reply.
Oh, he will file reply.
I think he's appearing for the Civil Supplies Corporation. OP2.
You are appearing for whom?
OP2.
I'm appearing for the Civil Supply Corporation OP2.
Civil Supply Corporation. Yes.
As well as for the OP5.
So file your opposition.
No,
I'll file it.
for the petition, state will take a fine.
We'll file an affidavit manage. State will.
There's a miscase.
One week, within 1 week, file your counter affidavit.
Within
1 week.
Till then, no third party right be created.
That has been created.
No third party right be created.
Third party right has already been created.
Where is it?
He will disclose.
He has made him a party.
Mr. Mishra, you probably were appearing for 2 and 4.
2 and 5, your lordship.
5 is a
5 is a party here.
Yes.
5 is a party. How can he appear for the corporation and also the?
You are for 2 and 4.
My friend is appearing in the corporation.
2 and 5. The numbering is wrong, my lord. 5 double name. Otherwise, it has been numbered at
Okay.
No, 4 is the district manager.
No, there are 2 5.
Problem.
2 4
5.
4 are there. Oh.
2 fours.
Right.
So
that is how it is 5.
No third party right be created actually.
Man, he has already made him a party. Yeah. Only a week, man, I will file it, man. I have to see.
I'm unable to hear my friend Mr. Mishra.
He has become louder than the required.
No, when he's in difficulty, he speaks slowly. Mr. Mishra goes to the VC and he speaks slowly. Suddenly he'll turn up on VC. Actually, can you see the guidelines speak about one kind of committee consisting of a certain team of officials. The meeting has been convened by a second team of officials who are not fully in sync with the guidelines, and the meetings have been signed by a third team of officials who are not the selection committee. So in that view of the matter, my lord, and collector is at the helm of the affairs.
Only when he found that he has not been selected.
My learned friend's client is not in the helm.
I have clarified that. Only a week
Young
time,
colleagues,
your lordship.
States.
31st, I will just come back with a reply.
Let him not create any third party. Let the state not create a third party. That's all.
But that will stall the process. This is not my personal interest.
Third party interest has been created.
No.
But the OPC
My information has not been created.
Oh, if you speak, then I can't hear him.
I'll not.
Yes, Mr. Mishra, third party interest has been created or not?
Man, he has in fact challenged the selection of opposite party number 6. He has already been selected.
Created.
Selected, not created. He has not started operating.
But I just received the comment. I'm yet to go through it. Man, just received it.
Oh, he is handicapped. He is handicapped. Keep this matter on Monday. We'll see to it. Come on Monday. Let us see.
Wait.
Let's give we wait for 1 week time to file counter affidavit.
So I have also appeared for the number 6.
File counter affidavit by the opposite parties within a week from date. matter to be listed. After 2 weeks, it is open to the petitioner to
Your lordship already issued notice and passed an interim order protecting.
but ED not received. It appears that the service is not complete.
Before I have been engaged.
Passover. Next.
But please to issue notice.
Commissioner.
64 lordship tender 2025 without participation they have challenged. I am the successful bidder lordship.
No, and I'll explain. That this is there is a.
When?
By your lordship, in fact, has been pleased to issue notice in the matter for adjudication. My interim application is there, in this matter. Here, what they have done, they have also decided.
But ED have not returned. You are representing whom? Opposite party number?
No, I am representing.
High lordship.
Who is 224?
Lordship 4 I am.
There are 4 only.
4 I am for 4.
Here for 4.
So what about 2 and 3?
Cuttack
municipal.
CMC.
With the petitioner.
CMC. 2 and 3 are same.
Anyhow, come in the next week. We'll see to it.
My.
65. Yes, this is the button.
Item 65. Item 65, my lords, on the last occasion, Union had filed its counter. My lords, I have filed the rejoinder. Let it come on.
Yes. Have you been served with a copy of the rejoinder?
I was served in their office. The adjudicator.
But today they have.
Horizontal.
Filed today.
They are saying.
Horizontal.
Horizontal.